everyone, today I'm going to be talking to you about Schedule 3 and Schedule 3 waivers and what you need to know in the context of your partner visa plans if this is going to apply to you. First things first, Schedule 3 and Schedule 3 waivers only apply in the context of an onshore partner application, so if you're planning to lodge your visa from offshore, you're not going to need to worry. So what actually is Schedule 3? Schedule 3 is a set of additional rules and criteria that apply to certain bridging visa holders or people that don't hold a valid visa who want to lodge an application in Australia. Essentially, it's a framework built into the migration legislation that encourages people to make sure that they lodge their new application before a current visa expires, dissuades people from remaining in Australia without a valid visa, and encourages people to see through one visa process before they start the next. Essentially, they don't want people to take advantage of time spent on a bridging visa to manipulate the circumstances or reach the eligibility criteria for a new visa, unless there are compelling circumstances. The idea is that if you want to change paths and you haven't received an outcome, you should be going offshore to lodge that new application. If you don't meet the criteria for Schedule 3, your visa application will be refused. The exception to this is where there is a waiver provision, which does exist within the partner visa framework. The most common scenarios we see are people that have overstayed their visa or become unlawful because they were unaware of their expiry date, or in cases where somebody has had a visa refusal and is waiting on an appeal with the Administrative Review Tribunal, or extended processing times have led somebody to be the holder of a bridging visa for an extended period of time and there's a change of circumstances and they're now wanting to pursue a partner visa instead of the original application. This might be because they finished a course that they were studying, a change of employment, or they simply no longer meet the criteria for the original application. If this sounds like it might be you, it's really important that you get tailored advice so that you understand all of the criteria for Schedule 3 in detail and what you need to be aware of in the context of your partner visa plans. The department are tough critics and they won't accept circumstances such as you were unaware of the expiry date, you were relying on a third party such as a visa agent or your employer to assist with lodging a new application, or the processing times of an application are simply too long and it's not your fault that your old visa hasn't been processed. In the first instance, a detailed assessment of your exact circumstances, how long you've been the holder of a bridging visa or not holding a valid visa, is the first step in determining do you meet the Schedule 3 criteria or are you going to qualify for a waiver. Now, a waiver applies in the context of a partner visa, but it's certainly not a get out of jail free card. The bar is set high, and with the intent of the overall provisions of Schedule 3 in mind, it has to be genuinely compelling circumstances. As a general rule, the mere existence of a genuine relationship with your partner and not wanting to be separated from them during the processing times of an application isn't going to be sufficient grounds to justify the waiver of the Schedule 3 criteria. This is because within the context of a partner visa, it's common to be separated from your partner. So what is considered compelling? There's no specific list of what circumstances can be considered compelling, and each application will be assessed on its own merits. Some examples of compelling circumstances might include where there's a child or Australian citizen of the relationship that would be significantly impacted by your departure, war or civil unrest or safety concerns in your home country, or severe illness or medical issues that would cause extreme hardship. Schedule 3 waivers are complicated and successes can be few and far between. If you think you might fall into a category where you need assistance with Schedule 3 or a Schedule 3 waiver, it's really important that you get tailored advice that's unique to your circumstances. During our visa planning sessions, I'll sit down with you and your partner and go through your visa history and all of your circumstances in detail so I can advise you on what your prospects of success are in relation to Schedule 3 or a Schedule 3 waiver. In some cases, a new strategy may need to be put in place, but I can help prepare you for the journey ahead and all of the considerations.